Good afternoon. Thanks so much for joining us. It's great to have you all here. I am Janice Kaminer-Resnick, and on behalf of Jews United for Democracy and Justice and Community Advocates, Inc., I welcome you to our America at a Crossroads program. For the past 3.5 years, each week on Wednesdays from 5 to 6 Pacific time, we have sought to fulfill this objective: to provide an outstanding weekly forum with the very highest quality guests, all designed to ensure that we are prepared to advocate for our democracy, to decry authoritarianism, and to encourage informed and enlightened civic participation. Welcome to our thousands of loyal weekly viewers who hail from every state in the Union and from many other continents as well, and a special welcome tonight to our C-SPAN audience. If you are not on our list to receive notices and links to our weekly Zoom programming, go to cai-la.org, that's cai-la.org, and sign up for our list. A special welcome as well as a thank you to the exceptional election and voting rights law guru Rick Hasen of UCLA Law, which happens to be both David's and my alma mater, and to the always astute and probing Patt Morrison. Thank you both for sharing your brilliance with us and ensuring that we fully understand recent court rulings. Next week, we will welcome the New York Times Jerusalem reporter Isabel Kirshner, who will be in conversation with former two-time U.S. Ambassador to Israel, Martin Indyk. They will be discussing Kirshner's recently released book, Israel, the Land of Hope and Fear, The Battle for Israel's Inner Soul. Kirshner has been a reporter for the New York Times in Jerusalem for many, many years, and is sure to be an extraordinary hour with all of the changing dynamics in that country. The following week, on July 19th, we welcome two of the country's most impressive and respected political pundits, Democratic consultant Robert Shrum and Republican consultant Mike Murphy. They'll be looking ahead to the upcoming primaries and tell us where they think we are heading in 2024. You'll want to be sure to tune in. Now for a couple of additional announcements, my colleague and friend David Lehr. David?
Thank you, Janice. And I join Janice and welcome you all to America at Crossroads on behalf of community advocates. A special greeting to our nationwide live C-SPAN audience. We hope you will all become regular viewers of our weekly town halls. At the end of the program, you'll see a link to our website to sign up for future notices, as Janice mentioned. In upcoming weeks, after the programs that Janice mentioned, we'll spend July 26th with New York Times op-ed columnist Michelle Goldberg, who returns to dialogue with Warren Aldi. She is always provocative. On the following week, on August 2nd, we take a bit of a detour from our usual political orientation with an exploration of what's new in America's religion. We welcome Mark Oppenheim, author, professor, and for years, the man behind the New York Times column, Beliefs. On August 9th, we dive back into current events with one of our favorite guests, former ambassador to Moscow, Mike McFaul. He's a professor at Stanford. He's the head of the Freeman Spogli Institute there and at the Hoover Institution. He will discuss the Russia-Ukraine war and what the facts and currents are in Moscow and Kiev. He will be interviewed by Stanford's democracy maven, Larry Diamond. Our moderator of last week returns, the wonderful Patt Morrison. She's an interviewer extraordinaire, as you will see if you've not seen her before. She's an LA Times Pulitzer Prize winning columnist, as well as recipient of Emmys and Golden Mikes for her work on TV and radio. She is always a joy to listen to. Pat?
David, thank you so much. And thanks to everyone who makes this program possible and to the C-SPAN viewers joining us tonight. To those of you who are joining through the JUDJ link, you can put your questions for our guest, which we'll get to a little later in the program, in the Q&A box, and we'll get to them and put them to Rick Hasen, who may be familiar to you through lots of other programs and his writings far and wide. He's the internationally recognized expert on election law and campaign finance regulations, a professor at UCLA's Law School, where he directs the Safeguarding Democracy Project, which is a project working to ensure that elections in this country remain fair and free. He writes for major publications, is the founder of the Election Law blog, and his recent book is Cheap Speech, How Disinformation Poisons Our Politics and How to Cure It. Rick, always a pleasure to talk to you.
Oh, it's great to be back with you, Pat.
It's been an eventful couple of weeks when it comes to election law, who gets to vote and who doesn't in this country, because as we know, there are 50 different elections at least, and not a single national election. But if setting the rules for the 2024 election were a dinner party, How far along are we in getting those rules put in place? Are we past the appetizers and into soup? Are we already at the entree? How much is already set and ready to go?
Well, what I would say is that there may be plans for what's going to be for dinner, but I would not count on those plans sticking everywhere. We have plenty of time for state legislatures to pass new laws, for local election administrative bodies to change the rules, and for lawsuits, lots of lawsuits. We're a very litigious society. You mentioned that we have a decentralized election system. That means that there's lots of places where there can be problems. There's lots of places where people can fight over the rules if they think it's going to be to their advantage. So, we know what day dinner is being served, but beyond that, there are certain rules that are still being fought over and fights yet to come.
There were a couple of significant Supreme Court rulings before the court left town for the summer break, having to do with redistricting, which also has a tremendous impact on elections, who gets to go to Congress and what Congress ends up looking like, and also with a kind of far out theory that was being tried out by some states that the Supreme Court said, no, not so fast. So let's get first to the redistricting decision, which is Allen versus Milligan. I believe it's Alabama. What was the case about and what did the court find? Because redistricting has been one of those tools that has been in use over the last 10 or 12 years to kind of chip away at the larger umbrella of the Civil Rights Voting Rights Act.
Sure. So in every state that has more than one congressional member, you've got to decide how you're going to elect them. And Congress passed a law that says they have to be elected from a single member district. So if you've got two members, you've got to divide the state in half. And even though the Supreme Court has said since the 1960s that you have to have equal numbers of people in those districts, there are lots of ways of drawing those lines. There are ways of drawing those lines to give partisan advantage or to give advantage or disadvantage to one group or another. Since 1982, when Congress amended the Voting Rights Act, there's a part of that act called Section 2. It requires that in certain circumstances, district lines be drawn so that minority voters can elect their candidates of choice. And so these districts, they're sometimes referred to as majority-minority districts or minority opportunity districts, are drawn in such a way so that Black voters or Latino voters or Asian voters who are geographically concentrated, when there is what we call racially polarized voting, meaning white voters prefer one set of candidates, the minority voters prefer a different set of candidates, it gives them a chance to be able to elect their candidates of choice. And it's one of the most important tools to assure that our Congress, as well as state legislatures and local bodies, reflect the preferences of all of the voters who live in their districts.
So that is essentially, that means that you can't take a minority community and divide it up 2 or 3 ways to dilute its voting power.
So there are things you can do to dilute voting power. One of them, as you mentioned, is that you could crack the population, right? So you can say divide the population down the middle. I remember when I spoke maybe 5 years ago at the University of Texas at Austin, I was speaking to law students. Even though they all lived in the area, they lived in 5 different congressional districts because they divided up Austin, which was a Democratic stronghold, so that the Democrats would have less chance for power. So cracking is one thing. The other thing you could do is pack. So if you've got a bunch of reliable voters for one party, you put them all in one district. That district elects, the preferences of the people there, but then you can't use some of those voters in another district. And so packing and cracking, these are the 2 main ways that lines could be drawn to dilute someone's power. And since the mid-1980s, the Supreme Court has said under certain circumstances, the Voting Rights Act requires that you don't pack or crack minority voters and you give them a chance to draw their lines. Now, what happened this past year is that in Alabama, a 3-judge federal court, one made up of 2 appointees of President Trump. So these were not, liberal judges by any stretch. They found that under the law as it existed from the Supreme Court, Alabama, which has 7 congressional districts and only 1 majority Black district, had to create a 2nd district in the area with the so-called Black Belt counties, a group of counties in rural areas where a number of African-American voters live. The Supreme Court put that on hold as it decided to take the case, the result being that Alabama was able to run its election under the lines it wanted, not the lines that the judges said had to happen in 2022. But the court just decided the case, and it's somewhat surprisingly, with John Roberts, the Chief Justice, writing the opinion, said that indeed it looks like Alabama is going to have to draw that second district. Rather than accept the invitation that Alabama was coming up with to rethink the Voting Rights Act and essentially do to it what the court did to affirmative action in education a couple of weeks later, the court said, we're going to keep the status quo. And under the status quo, it looks like you're going to have to draw a second Black district for Congress in Alabama. And this is going to have ramifications in some other states as well.
Well, that was my next question was it a narrow ruling, or does it affect other states who were trying to do the same thing?
So in lots of states, when it's possible to draw these majority-minority districts or minority opportunity districts under the Voting Rights Act, they've already been drawn. But there are certain places where they haven't. There's a big case out of Louisiana that the Supreme Court was holding until it decided this case in Alabama. It sent it back to the court in Louisiana and probably will get another Black majority district in Louisiana, maybe in Georgia, maybe in Texas. There are, maybe half a dozen seats that could be up for grabs thanks to this ruling. I mean, the headline is the court said, keep applying existing law, but that's a huge victory for voting rights, given what we've been expecting from the Supreme Court over the last few years. And when Congress is so closely divided, 5 seats is nothing to sneeze at. And
that's the other headline, is that this could be one means by which Democrats could claim a majority in the House, given how close it is.
Right. And there are lots of factors. The Supreme Court a few years ago said that federal courts can't police partisan gerrymandering. So there's still lots of things that can be done to favor Republicans, or in places like New York to favor Democrats. There's lots of things state legislatures can do to draw lines. But, when it's so close, something like a 5-seat shift could make a difference.
The other ruling that got a lot of attention, well, there's several of them. This one is Moore versus Harper. There was a fringe theory called independent state legislature, which ended up not being so fringe because a lot of states, Republican-led states, were seriously considering it, where the legislature could vitiate the election results, throw them out, and not have to deal with the state's own courts in essentially deciding who in that state won an election. And this was significant because, in a way, I wonder whether it would ever have come to the Supreme Court in the first place, even 10 years ago, but that it batted down this fringe theory does take away some Republican legislatures' ability to essentially call the election results in their states, no matter what the voters voted for.
So I would say, I've been talking about election cases for 25 years with people like you, and this is the most complicated one of them all. So let me just take a minute and try and explain what this is all about, because there's a lot of misunderstanding about this case. So the Constitution says that when it comes to congressional elections, state legislatures get to set the rules subject to Congress's override. And for presidential elections, it says the state legislatures get to set the rules, full stop. That's in Article 2 of the Constitution. Congress doesn't get to pass legislation in this area. And so the question is, when the state legislature sets the rules, is it like some free-floating body that can just do whatever it wants? It is like that when it votes to ratify amendments to the Constitution. It's just the state legislature that votes. But what about when it passes an election law? Suppose it passes an election law that violates the state's constitution, because state constitutions protect the right to vote. The theory of the independent state legislature is the idea that the state legislature can act in congressional elections and in presidential elections, and it can't even be constrained by its own courts. And it can't be constrained by state constitutions. And the Supreme Court on that question was 6-2 in rejecting the theory. One justice, Justice Alito, didn't express a view on the merits of the case, just thought it was moot and it shouldn't have been heard. So 6 justices rejected this idea. And it's really important if we think back to 2020, when Trump was trying to reverse the results of the 2020 election. He was trying to get state legislatures to come up with those alternative fake electors. It was based in part on this theory that these state legislatures had this power, that they could even just ignore the votes of the voters. That didn't happen. fortunately in 2020, and now that door has been closed. So that's kind of part one of Moore versus Harper, and that is very good news. But there's a part two. So the part two is that the Supreme Court said in the last part of its opinion, and this was Chief Justice Roberts, Republican appointed conservative judge, Justice Kavanaugh, also Republican appointed conservative judge, joined by the liberals on the court in saying that the state courts, when they are interpreting state constitutions or interpreting state legislatures, can't interpreting state constitutions or state statutes, can't arrogate the power of the legislature. So what does this mean? It means that if you engage in a judicial interpretation that a federal court like the Supreme Court thinks has gone too far, a court can throw out the state court ruling and impose its own view of the question. Let me bring a very practical example to make this clear. In Moore versus Harper itself, the North Carolina Supreme Court said, we've read the state constitution, and the state constitution says that partisan gerrymandering is unconstitutional. And how did they reach that result? Well, it was based on very general language in the state constitution that said that North Carolina voters get free and fair elections. Well, how did they decide that? Well, the majority on that court was democratically elected, and those judges tended to be more liberal, and they believed that this is what the Constitution meant. There was then an election on the state Supreme Court, and now the state Supreme Court, dominated by Republicans, doesn't believe that anymore, and that's one of the reasons why the case may have been moot. But had the court reached this issue, it could have said that the state Supreme Court can't decide that the state Constitution protects against partisan gerrymandering if its interpretation goes beyond the bounds of ordinary judicial review. Bottom line, it means that the U.S. Supreme Court can second guess state court decisions in cases like this Moore versus Harper, or if we go back 20 years, 23 years to Bush versus Gore, what the Florida Supreme Court said Florida law meant. That's still a very big power for federal courts, and still leaves lots of room for machinations by judges who want to, step in and reverse what state courts have done.
Both you and the Supreme Court reporter and analyst Dahlia Lithwick have made this point, that the nature of the court and its willingness to overthrow deep precedent have now become so normalized that when the court upholds some modest, long-standing, middle-of-the-road, sensible law, it's being hailed as a victory for liberals, which says a lot about the climate we're in, but also what does it augur about the court itself and its standing and its kind of where it positions itself for the future.
Right. So I definitely think, whether you want to call it moving of the goalposts or shifting of the Overton window, whatever expression you want to use, I think our expectations have changed. So when the Supreme Court does nothing more than say, we're keeping the law as it is when it comes to voting, some liberals say that's fantastic. And it is fantastic because it's better than the alternative. But it shows you how the ground has shifted. Now, the court decided the Moore case on the Tuesday before the end of the term. It decided the Milligan case about the Alabama Voting Rights Act at the beginning of June. But then remember what happened at the very end of June. You've got the affirmative action ruling. Affirmative action in education violates the Equal Protection Clause of the Constitution, according to the conservatives on the court. You got the student loan case. Again, 6-3, conservative versus liberal, engaging in what Justice Kagan said was, in her dissent, was a violation of the Constitution in how the court was throwing out the forgiveness program that the Biden administration had put in place. You got the ruling on freedom of expression objections to providing services to people in the LGBT community in the 303 Creative case. All of this, these are deeply, and we're going to have a big gun case next term involving whether people who've been convicted of domestic violence can be deprived of their guns. On these big issues, the court is still very conservative. And just because there are a few cases where things don't go as poorly, it doesn't mean that we're not seeing this remarkable shift in power and rights in this country. And it's no surprise that public opinion about the Supreme Court has become more divided, more polarized, and Democrats and independents are not approving, of Dobbs, the abortion decision, Bruen, the guns decision, and lots of these other 6-3 really controversial decisions. The Supreme Court has only its legitimacy, right? It doesn't have an army, so it depends on people believing in it. And now I think we're going to see more people on the left consistently attacking the Supreme Court the way the right has been doing since we were in the era of Earl Warren.
Earl Warren, the former governor of California, who became the Chief Justice of the Supreme Court in the 60s, you saw bumper stickers reading "Impeach Earl Warren" for decisions that I can't remember, but I'm sure they involved the Voting Rights Act and the Civil Rights Act, which the court ended up endorsing. You do see Chief Justice Roberts, you get a sense that he's trying to wrench the steering wheel away from some of the associate justices on some of these cases, keeping in mind just what you said, that the idea of the legitimacy of the court is now under assault, even though he has refused to appear in Congress to talk about some of the ethics rules that the court should be, in many people's minds, following. What kind of success is he having in wrenching the court toward a middle that seems acceptable?
Well, in Dobbs, he was not successful. Remember, in Dobbs, he wanted to take the position that the 15-week ban in Mississippi was okay, but not throw out Roe versus Wade. There are 6 conservative justices on the court. It takes only 5 to reach a decision. So he didn't have his way there. But one of the things that I think we've been seeing increasingly at the court, especially this term, is and you mentioned this a little bit earlier in one of your questions, some of the conservative states and litigants are coming in with really far out arguments. So when Alabama came in to defend the Voting Rights Act, it didn't argue, you should make a little tweak to the standards that have been placed in the 1980s. They proposed a really radical rereading of the Voting Rights Act that essentially would have turned a statute that is race conscious, that says the states need to care about race when they draw district lines, into one that's race neutral. We already talked about in Moore versus Harper, the argument that the legislators were making that they had unbridled power when it comes to congressional elections. This has proven to go too far in some cases for Justices Barrett and Kavanaugh. So, I can't say this about every case, but we can kind of see those 3 justices, Roberts along with Barrett and Kavanaugh, as at least in some cases willing to move more incrementally. Roberts has always been an incrementalist on the court. He didn't have incrementalists at his side when it came to overturning Roe, but he had some success this year. Now, it's really hard to know why that is. I mean, one possibility, as you just suggested, is that it's about ethics. One of the reasons the Supreme Court is losing popularity is because some of the justices, especially Justices Thomas and Alito, have been involved in questionable ethics practices in terms of reporting gifts, reporting free trips. In the case of Justice Thomas, reporting that his mother had her home bought by a wealthy benefactor in Texas who also paid for Justice Thomas's nephew's private school. There's a perception in the public that there's something wrong with the Supreme Court. And I think that in part, those ethics scandals in part, maybe are moving some of the other justices towards incrementalism. I also think that the opinions themselves, because the Supreme Court has kind of limited political capital, the justices are choosing their battles. When it came to Allen versus Milligan, the Alabama redistricting case, as soon as that was decided, I wrote a piece in the New York Times saying, just wait for affirmative action. Allen is the way of showing to minority voters that minority plaintiffs don't always lose at the Supreme Court. And Roberts can always come back a few years later. And Justice Kavanaugh, in his separate opinion in that case, said, there are some other good arguments that might be made against the Voting Rights Act. I'd be happy to hear them in a future case. So it's not as though it's one and done with these cases, but incrementalism seems to be the calling card this term.
In the affirmative action case, the result was what people expected in initiating the affirmative action programs at the universities in question. But there seemed to be, again, from Alito and Thomas, a sort of sense that color blindness, that blindfold on the statue of justice really works. And curiously, I think Justice Thomas cited the Freedmen's Bureau after the Civil War, which was created for emancipated Black people to have their own land and farming. And he said, well, that was a colorblind program. It was a program created for Black people. So you wonder, yes, affirmative action has been thrown out in this context, but what are the ripple effects throughout the rest of the system, not just the academic system?
Well, the first thing to note is that, we haven't mentioned this yet, is the presence of the newest justice, Justice Ketanji Brown Jackson. She wrote a separate opinion. And, someone like Justice Thomas, people watching may not be aware of this, but he calls himself an originalist. That is, he's someone who believes that the Constitution should be interpreted along the lines of what he'll call the original public meaning. What did people at the time think that the Constitution meant? And Justice Jackson has been pushing, and she was doing it at oral argument back in that Alabama redistricting case, what historians have said, which is that at the time that the 14th Amendment, the 15th Amendment, these are the Reconstruction Amendments after the Civil War, at the time that they passed, Congress did not view the law as colorblind. They viewed it as race conscious. That is, they didn't think they were the ones who passed these amendments, right? And they're the ones who then passed laws implementing those amendments that gave preferences to newly freed slaves and to other African Americans throughout the United States. And so if you're an originalist and you take the history of the 14th Amendment seriously, Justice Jackson says, you've got to accept that race consciousness is okay under the Equal Protection Clause of the 14th Amendment. So it was in that context that Justice Thomas, who calls himself an originalist, was trying to explain why he thought that his view was consistent with originalism. And I think for the reasons you gave, he failed miserably at that. But if you go and look at John Roberts' opinion, he's not playing up much originalism at all. He's just kind of writing a short opinion that says this is no longer constitutional and trying to parse the precedents of the Supreme Court. He's trying to lower the temperature, but the bottom line is you've got now a supermajority on the court that is willing to spend its capital on the big ticket items like abortion, guns, and affirmative action. And to get to your question about what's coming next, there could be challenges to affirmative action programs in employment, in other areas. I was worried about the Voting Rights Act, and the majority fortunately did not say anything about the Voting Rights Act, but that too is a race-conscious law, just like Title VII, which is the main federal law that protects against race discrimination in employment. So this is an iterative process. There will be new cases brought in the court. Every June, we kind of have this trepidation about, what's the next shoe that's going to drop.
There is a question that I'm going to frame in the context of a ruling in Florida by a federal judge this week, that Florida had a law saying that if you are collecting voter registration forms, submitting voter registration forms with a community organization, an innocuous practice that goes on virtually over the whole country, if the person doing that is not a citizen, simply a green card holder, even though someone who's authorized to work here in that kind of capacity, that organization could be fined $50,000 for having that non-citizen person collecting those signatures, collecting those votes. And a federal judge said, no to that. And so the question from Lisa is a larger one, the context about measures that are put in place to limit voting opportunities, to shrink down voting days, to stop voting by mail, to stop drop box voting, and that sort of thing. Where do those measures stand as we approach 2024?
So unfortunately, the Supreme Court has been weakening both constitutional protections and protections under the Voting Rights Act when it comes to these kinds of laws. That judge who issued the decision in Florida issued other decisions earlier in Florida, striking down other Florida laws, and he's been reversed by the much more conservative 11th Circuit Court of Appeals. So I'm not at all certain that his ruling is going to stand. One of the things, we talked earlier about this idea of seeing preserving the status quo as a victory. One of the things that is clear is that the Voting Rights Act now, as it's been interpreted, is a lot weaker than it was even 10 years ago. Not because Congress weakened it, but because the Supreme Court has, in a series of earlier cases, most importantly in this area, a case decided in 2021 called Brnovich versus Democratic National Committee, has read the Voting Rights Act in a way that is very protective of states. One of the things Justice Alito said in that opinion 2 years ago was that if a voting practice wasn't in widespread use in 1982, when the Congress amended the Voting Rights Act, then you don't have to protect it today. So there were no drop boxes in 1982, so it doesn't violate the Voting Rights Act not to have drop boxes today. There wasn't much voting by mail in 1982. And so it's kind of turning back the clock. And so I'm afraid that in the states that want to engage in the most suppressive activities, there is very little that the federal courts are going to do about it. And in a place like Florida, where the Florida Supreme Court is dominated by conservative justices, it's not likely that the state courts are going to provide much relief either. So, this is a victory for voting rights in Florida this week, but let's check back in 6 months. It may not still be standing there.
Michael wants to know about the affirmative action decision, whether it means that federal set-asides for women-owned and disadvantaged small businesses are now thrown out. Are there more cases coming along that will shape and define affirmative action in a larger context beyond what the ruling is that the court just made about universities?
That's a great question. So all the Supreme Court decided was that the way that Harvard and the University of North Carolina, who were the two universities whose programs were at issue in those affirmative action cases, the way that they were doing it violated the Constitution, violated a federal statute. That's all they decided. They said, we're not saying that even educational institutions can't consider race in the context of someone's individual essay, where they write about their own experiences or the roadblocks that they face in their life. So that's all that was decided. What's going to happen now is that there are going to be a series of cases around the country, and there's going to be a lot of judge shopping, where you go file your lawsuit in a place where you expect you're going to have a sympathetic federal judge is going to be the one that's going to be assigned to hear the case. There are going to be attacks on set-asides. There's going to be attacks on all kinds of programs that are race conscious or gender conscious. And then they're going to work their way up the courts. And it'll take a few years probably, but eventually these cases will make their way to the Supreme Court. And maybe the Supreme Court will have the same justices on it and reach the same conclusion as they did in the affirmative action cases, or maybe they won't. I certainly think that the way the public reacts to these rulings will have some effect on what the Supreme Court ultimately does in these cases.
Do you know anything about the status of the working through the system, the Georgia case about the election tampering supposedly committed by President Donald Trump, calling and looking for 11,000 more votes? And then there's now video of President Trump calling Governor Ducey of Arizona. He's signing a document, and you can hear his phone ringing with "Hail to the Chief." He knew that this was Donald Trump calling, and he clicked on the phone to not to answer the call. These two become, in a very significant constitutional matters and election results and what happens with them. There was just a report, I believe, in the Washington Post that Ginny Thomas, the wife of Clarence Thomas on the Supreme Court, contacted 29 members of the Arizona legislature about their votes when Arizona went for Joe Biden in 2020. So have you any insights, any updates on what's going on in those matters?
Well, so we know that in the Georgia case, this is a case that is being looked at by the district attorney in Fulton County, where Atlanta is. In that case, the district attorney has notified law enforcement that she expects to be deciding on indictments and announcing something in, I believe she said, from August 1st to early September, and that they're putting kind of police on alert. I think it's very likely, based on that information, that Trump is going to face a state indictment in Georgia for violating Georgia's election laws. We also know that Jack Smith the special prosecutor who recently indicted Trump on the federal level for the classified documents sharing of information, is also still examining whether he might be liable for federal crimes related to what he did after 2020 in trying to reverse the results of the election. For lots of different theories. One, it might go after those fake electors that we talked about. Maybe that was trying to defraud the Congress or interfere with election processes. We know there's been recently, I think there was just a report today that Jack Smith has been trying to get information from Arizona legislators, although not yet from the governor, Doug Ducey. So there's a widespread investigation. We know that Trump's main political operative, a guy named Mike Roman in Pennsylvania, is cooperating, according to reports at CNN and the New York Times. He's cooperating. And Rudy Giuliani engaged in conversations with Jack Smith over these kinds of things. So it would not surprise me if there is a federal indictment of Trump on some of these charges, but it also wouldn't surprise me if there were not, because unlike the classified documents case, which seems, if the facts in the indictment are true, pretty cut and dried, there may be some novel legal theories. And so there's going to be both a legal calculation and a political calculation about whether or not charges should be brought against Trump for those election-related activities from 2020.
Expanding the Supreme Court has been something that politicians have talked about for and against, going back to FDR. And there's been a question now, an issue of expanding the court, something that, according to Ariella, wanting to know whether that would be a counter to the rightward tilt of the court. And President Biden seems to be resisting that idea, probably because of the swimming upstream odds that it would face and the political cost of even proposing it.
Right. So Biden is going to be running for re-election. There's no way that this Congress is going to add justices to the Supreme Court, even though it has the authority to do so. You've got Republicans controlling the House of Representatives. They're not going to support this. This would be subject to a filibuster in the Senate. So you're not going to get 60 senators who would support this. So there's not much political upside for Biden to embrace this now, even if it's something that he believes in. Something down the line that could happen, it's possible. I think it's still seen as a pretty extreme measure. One of the things that has been proposed that seems to have a little bit more bipartisan support is 18-year term limits for Supreme Court justices. After the 18 years, the justices can retire, or they can still hear cases. They just wouldn't serve on the Supreme Court. That would get around the life tenure issue. You could just have them serve in another capacity. Maybe that requires an amendment. Amendment, remember, requires 2/3 of Congress in each house and 3/4 of the state legislature. So that's a tough slog there. But I do think that there's going to be more and more calls for changes to the Supreme Court. Other things that can be done is potentially taking away the jurisdiction of the justices to hear certain kinds of cases. The thing is, when you've got divided government, none of these things are going to happen. So it would have to happen when one party has enough control of Congress and the presidency to be able to get it through, or some kind of crisis that leads to bipartisan cooperation.
And what seems like a crisis, at least a minor one, is what you referred to earlier in the program, which is the ethics issues that have arisen with ProPublica's investigation of Clarence Thomas and Samuel Alito. There was a question of Samuel Alito not declaring a seat on a private plane on a flight that he took to some luxurious spot, and saying that, well, the seat was empty anyway. And this is an argument the next time I get on a plane and go through first class heading to my coach seat and notice an empty seat, I'm going to use the Alito argument and see if it works. But this too may be written into law and ethics standard to be applied to the Supreme Court the way it is to other federal judges.
Well, they've already clarified the law so that Justice Alito would clearly have to report that free flight that was offered to him by Paul Singer, a billionaire who later had business before the Supreme Court, would have had to report that. So there's been a little bit of change already, but Chief Justice Roberts has resisted and even claimed that it would violate the Constitution's separation of powers for Congress to pass rules that would require Supreme Court justices to recuse in certain cases. One of the things that I think people don't know about the Supreme Court, unlike our state Supreme Court, on our state Supreme Court, if a justice needs to recuse, maybe they own stock in a company that's before the court, the Chief Justice will appoint someone else, have a whole process, a randomized process, to appoint someone else to sit as a justice on the case. At the US Supreme Court, they don't have that. And that means you might have an 8-justice court, which could divide 4-4. So there's already a reason that the justices are reluctant to recuse, because it might lead to a divided court. But it is, I think, the height of hubris for the Supreme Court to think that it alone should be above ethics rules. And, it doesn't even have its own ethics code. Who decides if Justice Alito is violating the rules that would require recusal? Justice Alito, right? The justices don't even vote on their own. So I think something has to be done. Justice Alito, his defense was even worse than you described. He claimed that he was entitled not to report. The form said he had to report anything he'd gotten except for personal hospitality for food, entertainment, or lodging, of which a plane ride is none of those things. And he claimed that the reason he could do that was because the form said that if it was hospitality on property or facilities owned by a person, then he didn't need to report. So he claimed that an airplane was facilities. And for someone who calls himself a textualist, that's not how people speak in the English language. The only facilities on an airplane are the bathrooms, right? So he went to the Wall Street Journal. He tried to pre-butt the ProPublica article, went to the Wall Street Journal opinion page and wrote this really unconvincing argument. And I think he actually did himself a lot of damage, but it just showed you, why should Justice Alito alone be deciding if Justice Alito is following the rules? No one should be above the law. I mean, the Supreme Court said that in Clinton versus Jones, when Bill Clinton was sued by Paula Jones, that even the president is subject to the normal rules. We're seeing that brought up against Donald Trump when Trump is claiming some immunity when he was accused of rape and sexual assault by E. Jean Carroll. So why not the Supreme Court subject to the same rules as everyone else?
So Chief Justice Roberts doesn't have the muscle within the operating body that is the Supreme Court to say, hey, guys, you're really hurting the whole institution with this nonsense. Knock it off.
So he's got the power of persuasion. He is the one who organizes things and sets the calendar, but he has no more authority to impose rules. He would have to convince a majority of justices to go along. And, these justices, do you remember that play, No Exit by Jean-Paul Sartre, where like people are stuck, hell is other people? These justices are stuck together for sometimes decades. And so it's very difficult to, hold a grudge or criticize them or, publicly feud, because you're going to need their vote the next time. And, already we know that there was a tremendous loss of trust when the Dobbs draft opinion by Justice Alito was leaked to Politico a little bit of time, I think a month and a half before the Supreme Court actually issued its opinion. So there's already a lot of mistrust at the court. The justices are polarized like the rest of the country is polarized. And so I'm not sure what else Roberts can do. I would like to see the liberal justices come out and publicly say that there needs to be an ethics code. Just like Justice Kagan last summer, I heard her speak at the Ninth Circuit Judicial Conference, and she started criticizing the court and talked about the loss of legitimacy that comes with overturning a lot of precedents. And those remarks got a lot of attention, including from the Chief Justice. I think it's time for the liberal justices to speak out on ethics reform too. It may not be easy, but they're still on the wrong side of 6-3 votes, so I'm not sure what they have to lose.
You can post your question for Rick Hasen on the Q&A box at the bottom of your screen, and we'll try to get to it before the end of this hour. A lot of questions have popped up about the 303 creative decision, the one that said that a website maker who objected on religious grounds to gay marriage did not have to take the business of a gay couple wanting a website. The curious thing was that the supposed inquiry that triggered this was listed as coming from a man who it turns out that they found out who the man was. He's a straight man married to a woman and a website designer himself who had made no such inquiry. So in a sense, the whole decision was based on a theory and a supposed exchange over a business proposition that never took place. Is that even legal?
So I don't agree with the result in that case, but I don't think that this particular issue, that the person who supposedly submitted the form saying they wanted a website design for a same-sex wedding, that form may have come from someone else or may have been forged or something like that. The reason I don't think it matters is because this was a First Amendment case where the website designer and the state of Colorado, which was the defendant in the case, and the state of Colorado wants to enforce its anti-discrimination laws as to accommodations in businesses, they kind of stipulated to a set of facts. They said she wants to engage in this business, but she has values that would preclude her from representing a same-sex couple in the creation of these websites. And so these facts were taken as a given. And so it was enough for standing purposes to be able to show that there was a real conflict, for her to be able to say, I want to do this and I'm afraid I'm going to be prosecuted. And the state of Colorado say, yeah, if you do this, if you discriminate against same-sex couples, you're going to be prosecuted. So I think it was a real case. I don't like how it was resolved. It leaves a lot of questions. Justice Sotomayor, in her dissent, was saying this is going to lead to a lot of discrimination. Can you put up a whites only sign in a business? And the majority saying, no, you can't do that. It's only about expressive kinds of conduct. I guess, serving someone a hamburger is not expressive, but
So
where's that line
is
going
not
to be?
Maybe a hamburger isn't expressive, but a frittata is. It's
Right.
gonna come into the weeds, really get into the weeds on things like this.
Right. And, for the first time, the Supreme Court has now said that for the first time since, let me say, since the 1950s, the Supreme Court has now said that discrimination against some people because of what you believe in serving them in a business is constitutionally protected, even if there's an anti-discrimination law against it.
So then we're looking at the repercussive aspects of this. How far can it go? Can someone in a creative business saying, I don't choose to serve a mixed race couple, and are some protected classes more protected than others?
These are open questions. As I explained in relation to the affirmative action ruling, the Supreme Court issues a decision about a particular set of facts in a particular case. And then you get other people who then bring lawsuits that raise somewhat different facts. And then the lower courts have to read the tea leaves, read the opinions, try and figure out what the rule is. They'll fight over it. And eventually these cases percolate their way up to the Supreme Court, and the Supreme Court has to issue some follow-on ruling. Sometimes the law is going to be different in other parts of the country. What's allowed in California might not be allowed in Texas. And that's how our system is. It's a common law system. It's kind of an incremental system. It's not as though everything is by statute, like it is in some other countries. And really, it's the legislative body that decides all of these things. We allow 9 life-serving oracles to tell us how to resolve our most pressing and polarizing questions.
And of course, this system that we have means that someone who can legally vote for a presidential candidate in state A may not be qualified to vote in the same election as the same person in state B, which really is a head scratcher.
Well, we have this decentralized system when it comes to voting rules. There are certain rules that are imposed on the federal level, some on the state level, and some on the local level. What we really need, and this will have to be the topic for a future discussion, is we need a constitutional right to vote. It shouldn't be if you're an adult citizen, non-felon, living in a place as a resident, that you can be denied the right to vote or have impediments put up in front of you. Because if you go and look at the Constitution, you might be surprised to see it does not guarantee a right to vote. And we're going to keep having these fights over voting rules until we have some national standards for what it takes to be eligible to vote and what the rules are going to be in each place to be able to cast that vote.
And some of our viewers like Lois are saying, if Democrats take control of both houses of Congress and the White House again, will there be any willingness to nail down, for example, the right to an abortion, to nail down these voting rights in an airtight way that the Supreme Court or any other courts can't really undermine?
Well, one thing, as I mentioned a little earlier, is the filibuster. Democrats had passed a massive voting rights bill. They actually passed two. One that would have restored parts of the Voting Rights Act that the Supreme Court had struck down earlier. Got a majority vote, but it needed 60 votes, or Democrats needed to get rid of the filibuster when it comes to voting rights. At least two senators, Senators Manchin and Sinema, would not go along with blowing up the filibuster for this purpose. Democrats are not going to be getting 60 seats in the Senate anytime soon. So unless there's going to be a majority that's going to change that filibuster rule, even if there's a control of the presidency and a majority in the Senate and a majority in the House, it would not be enough to cause a change in voting rules. And I would say the same thing about abortion. Same thing about other areas like guns, although not every area. So we did see some LGBT protections passed on a bipartisan basis in the last Congress. And we did see Congress come and fix some of the worst aspects of the rules that are used by Congress to count the electoral college votes that Trump was trying to manipulate at the end of the 2020 election. So there are some areas where there could be bipartisan compromise, but on the big things that divide Democrats and Republicans, hard to see anytime soon that congressional legislation getting through unless there's a change in how the Senate does its own set of voting.
Let's talk a little bit about what future cases may be coming and what insights we have on them from decisions that have already been made. For example, the decision that the Environmental Protection Agency can't protect the environment when it comes to wetlands and some waterways. Does that argue that the court is going to revise and say there are even cabinet level positions where the federal government can't administer the very things it's supposed to be in charge of?
Right. So one of the things that we've seen from at least some of the conservative justices on the court is opposition to the administrative state. They think that federal agencies are too powerful. And this has both a constitutional dimension and a dimension of statutory interpretation. The constitutional dimension is the idea of delegation, that there are certain powers that Congress cannot delegate to an agency. And that's a theory that has been kind of sleeping, but Justice Gorsuch and some of the other conservative justices are trying to revive it. The other is when it comes to interpreting statutes, how broadly do you interpret it? And in that ruling involving the EPA and in the ruling involving the student loans that just came out at the end of the term, that was a question of statutory interpretation. Does the statute allow the government to go this far? There was another case involving COVID vaccines. Does the statute allow the government to require all workers at large businesses to be vaccinated? And in all of those cases, the conservatives applied something called the major questions doctrine. It's a kind of legal theory of interpretation that says, we're going to assume that Congress hasn't given the agency the power to do anything really big. If Congress wants to do that, it's got to write the law really, really explicitly. Where did this rule come from? It was kind of a creation of the conservative justices who are skeptical of the administrative state. And so we're going to see more decisions. And in fact, there's a rule that's been around for decades called Chevron deference, which is when there's two reasonable interpretations, the agency picks one, the courts will side with that one. If it's a reasonable interpretation, the Supreme Court is going to, in the coming term, decide whether to throw that rule out. That's been one of the pet projects of Justice Gorsuch. Again, someone who really opposes a strong administrative state. And so we'll see. And if that happens, it's going to mean even more lawsuits going against environmental regulations, health regulations, safety regulations, worker protections, all those kinds of things that we expect that an agency of a president is going to have the power to do to assure that our laws are being effectively implemented.
And yet you can't expect Congress either to play whack-a-mole with every last detail of authority or to foresee the future. If you write a telecommunications law that doesn't anticipate 5G, but you wrote in 4G, and there's a challenge based on 5G, how, here again, we're back into the weeds where Congress's will is pretty clear, but it didn't actually put down in ink every possible iteration of a law or an agency and its authority.
So in the COVID case that was about a year and a half ago, it was based on a 50-year-old law where Congress said that OSHA, the federal agency that deals with worker safety, could impose emergency regulations when there's a health threat. That wasn't specific enough because it didn't mention vaccines, right? Even though COVID wasn't around. Really broad language. Same thing in the EPA case, broad language about regulating clean water. Same thing in the student loan case. Congress gave permission to the executive to, under certain circumstances, forgive loans. How specific do you have to be? You're right, Congress can't be clairvoyant. And it writes general language because it doesn't know exactly what the future holds. And of course, what these members of the Supreme Court know is that when Congress is so closely divided, they're not going to overturn the Supreme Court's statutory ruling, even though they have the power to do so. If the Supreme Court says the statute means X, but it means Y, Congress thinks it means Y, they can come in and say, no, it means Y. But when the Congress is divided, they're not going to be able to do that. And the Supreme Court effectively is the last word. And the justices are aware of that when they issue these rulings.
So where are the numbers on the Supreme Court for this kind of broad decision saying, without the specifics, we are declaring that administrative agencies in the executive branch can't do what is essentially their job?
Well, that was really the 6-3 vote in both the COVID case, in the EPA case, and in the student loan case. And in fact, Justice Barrett, who used to teach this area of legislation when she was a law professor at Notre Dame before she was on the Supreme Court, she wrote a separate opinion in the student loan case to try to justify this major questions doctrine and explain how it's consistent with her normal theories of textualism, that you're supposed to interpret texts in a statute in a way that an ordinary reader of the English language would think that you should interpret it. Like that originalism that we talked about on the constitutional level, there's a parallel theory for statutes. And Justice Kagan in dissent says, you guys are pulling a rabbit out of a hat. You know, where'd you come up with this doctrine? Why don't you enforce the statute the way it's written? Do what a textualist should do. And Justice Barrett is pushing back and saying, no, this is consistent with textualism. So they debate these issues at a very high intellectual level, but on the ground, it means that people who have student loans are going to have to pay them despite the Biden administration's loan forgiveness program, unless Biden can come up with a workaround, and that's what they're trying to do. So I think you use the term whack-a-mole. I mean, that this is really what we're talking about, and it's just lots of machinations to try to get around some pretty extreme Supreme Court rulings.
I'm reminded of the game Twister from the 60s. How everybody had to bend around to get to the point, to the dot they wanted to. We try to end on an upbeat note, Rick. So is there anything hopeful that you can point us to?
Well, so I think I was quoted in the New York Times as saying that the decision in Moore versus Harper was bad, but not awful. Sometimes taking bad is good enough if awful means the end of democracy. Allen versus Milligan, that voting rights case, kept things in place. It could have been a lot worse. And I think public pressure makes a difference. I think the fact that people, especially people on the left in the progressive community, are starting to pay attention to the Supreme Court and starting to talk about what the justices are doing, that this can make a difference. And so, you know, I view this as not a cause for pessimism, but a kind of a call to action. So that's about as optimistic as I'm going to get.
Rick Hasen, thank you as always, the director of the Safeguarding Democracy Project at UCLA. Next week, the New York Times Jerusalem correspondent Isabel Kirshner joins us, talking to the two-time U.S. ambassador to Israel, Martin Indyk, Wednesday, July 12th. At 5 p.m. Pacific. And our C-SPAN viewers, if you'd like to sign up for notifications about the upcoming programs here, you can go to the Community Advocates website, cai-la.org. You see the address right there. You can sign up to take part in these programs. You'll be able to ask questions yourself of our guests. So I want to thank everyone who's been watching. Thank you to the sponsors and supporters of this program. And of course, thank you to the guests who give so generously of their time and their ideas. I'm Pat Morrison. Thank you.